After we reconsider 2 cases. Yes. The discrepancy was the announcement.
Jeez. This nose is mild. She just. Ready. Thank you.
Good morning, everyone. This meeting is called to order. Mr. Troman, has anyone signed up for public comment?
Good morning, Commissioners. Wes Trotman, General Counsel. We have Ms. Beret, Sarah Beret. If you could go ahead and unmute yourself, introduce yourself for the record, and proceed. Ms. Beret?
Oh, there we go. Sorry. Can you hear me now?
Yes.
Okay, sorry about that. Good morning, Commissioners. Thank you for allowing me time to provide comments this morning. My name is Sarah Beret. I am the CEO of Pre-K for SA, San Antonio's award-winning early learning initiative. Pre-K for SA operates 4 licensed early learning and care centers, and we also support providers across Bexar County. We are also active members of Early Matters San Antonio and Early Matters Texas. I am here today to say thank you. Thank you for providing leadership in making much needed improvements to the child care services in Texas. I also want to thank TWC staff for their diligence in drafting proposed changes to Chapter 809 that will help to improve the quality of learning and care for our young children across Texas. While I must admit that I have not fully absorbed all of the proposed changes in the document, what I have gleaned on first reading is very encouraging. The staff seems to have done an exceptional job balancing the need to give providers time to change while also recognizing the urgent need for families and children to have improvements in our child care system. When the brains of young children are developing 1 million synapses every second, it means that not just every day, but every minute matters in the lives of young children. And so I appreciate that you and the TWC staff are taking serious the changes to improve our system by helping providers to get into TRS, giving them enough time to get in, but also recognizing that they cannot just stay at the base level forever. They need to continue moving on. And as just importantly, to provide the supports to help them increase their quality. I have not seen a provider that isn't interested in increasing the quality of services, but the economics of childcare don't always work out and allow providers to do that. So again, I'm here to say thank you for your leadership in helping to make a complicated system better and to commit to working with you and with TWC staff to continue to figure out how can we provide better services for our young children and their families while helping providers to run successful businesses. Thank you.
Commissioners, we have a few additional commenters when we get to item number 13.
Good morning, Ms. Miller.
Good morning, sir.
We have cases to reconsider under agenda item 3. Is that correct?
Yes, sir. We have 3 cases. Commission Appeals is requesting 2 letters of continuing jurisdiction and permission to resubmit 1 case. Case number 2856699 was voted on docket 46 on November 23rd, 2021. Case was not pulled for additional discussion. The commission unanimously voted to reverse an overpayment resulting from an earnings adjustment. It's been determined that the decision contains errors and cannot be implemented as written, making the decision void on its face. There's no indication that an appeal has been filed, but because the decision is void on its face, Commission Appeals requests a letter of continuing jurisdiction so that the errors may be corrected. Commissioner Alvarez?
I agree.
Commissioner Demerson?
Agree.
Mr. Chairman?
Agreed.
And the second case is case number 2842188, which was voted on docket 12 on March 22nd, 2022. The case was not pulled for additional discussion. The decision has not been mailed. In preparation for mailing, it was determined that 1 issue did not achieve a valid vote. So Commission Appeals requests permission to resubmit the case to clarify the vote. Commissioner Alvarez?
I agree.
Commissioner Demerson?
Agree.
And Mr. Chairman?
Agreed.
And the last case is case number 20-057991-7, which was voted on docket 6 on February 8th, 2022. The commission ruled that the employer's petition to reopen was timely, granted the employer's petition to reopen, deemed the wage claim partly timely, and awarded wages to the claimant, Commissioner Demerson dissenting. A decision was mailed on February 14th, 2022. There's no indication of an appeal. It has been determined that the employer's name on the decision is in question, rendering the decision void from inception. A Commission Appeals is requesting a letter of continuing jurisdiction so that the case can be resubmitted on the issue of the correct employer name. Commissioner Alvarez.
I agree.
Commissioner Demerson.
I agree.
And Mr. Chairman.
Agreed.
Thank you, sir.
No tax liability cases,
Correct. No tax liability cases.
no fair housing cases.
None, sir.
On agenda item 6, we have no wage claim cases on docket 14 or 15 pulled for additional discussion.
That's correct. You should have already received the wage claim short form dissent lists for docket 14 and 15.
I move we accept staff recommendations on the remaining wage claim cases on dockets 14 and 15.
I second the motion, except for those cases of which I'm dissenting as reflected on the wage claim short form dissent list for docket 14 and 15.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 14 and 15.
Motion passes with the exceptions noted.
Thank you, gentlemen.
Thank you. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 14. Please proceed when you're ready.
Case number 2898831, Commissioner Alvarez.
The AT decision on separation should be reversed. The employer testified that the claimant was fired for directing an implied threat at the owner. But the claimant submitted a recording of the final incident, and it contains no language that could be considered a threat. The owner testified that the claimant's discharge was not related to his having taken part in the Black Lives Matter event. The claimant's participation in a nonviolent protest that occurred in the parking lot of the work location is not misconduct. The owner testified that the claimant's participation in the event was not relevant to the discharge, and the employer did not state that the claimant's wearing his work uniform at the protest violated any policy. Therefore, the claimant was discharged for reasons other than misconduct. Reverse the AT, no misconduct, chargeback, sever validity, void adequate response.
We should modify the AT decision. The overwhelming weight of the evidence suggests that the claimant was terminated when he was seen on the employer's property during a protest. During the protest, the records show that the claimant wore a Guy Fawkes mask and admitted to wearing the employer's uniform. The employer received numerous complaints that the claimant's conduct was making others uneasy. Since the claimant knew or should have known that his actions could give the impression that he was representing the employer's interests when he engaged in the protest, the claimant's actions were mismanagement of his position of employment and constituted misconduct connected with the work. Hence, we should modify the AT decision, misconduct, no chargeback, sever the validity of claim, and adequate employer response issues.
Reverse the AT, no misconduct, chargeback, sever validity of claim, void adequate response.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 2941464, Commissioner Alvarez.
The AT should be modified. I agree that the claimant filed a valid claim. Regarding the separation, the record was undisputed that the claimant stopped working because she was pregnant and just 3 weeks from her expected due date. Although the claimant subsequently told the employer that she could not return to work because she had moved, by that time she had already separated from employment. She was already separated from employment. As it has been nearly 2 months since the claimant had performed work or been paid. Since the claimant's separation was the result of her pregnancy, the claimant is entitled to benefits without disqualification. Modify the AT valid claim, no voluntary leaving.
We should affirm the AT decision. I agree that the claimant filed a valid claim. Concerning the job separation, although the employer expected the claimant to return to work after her delivery, she failed to do so. The claimant failed to contact the employer or make any attempts to return to work. Though the claimant alleged that she was discharged, the available evidence dictates that the employer contacted the claimant several times following the birth of her daughter to inquire about her return. The claimant failed to return to work as requested by the employer and thereafter filed her initial claim for unemployment benefits. As such, the claimant's separation constituted a voluntary quit without work-connected good cause. Therefore, we should affirm the AT decision, valid initial claim, voluntary leaving.
Modify the AT, valid claim, no voluntary leaving. Memo to investigate claimant's ability and availability for work.
Short form dissent.
Yes, sir, Commissioner Demerson, and we will send that memo, Mr. Chairman.
Case number 2967937, Commissioner Alvarez.
The decision is not correct. The claimant experienced medical complications brought on by a type of work she was required to perform. The claimant informed the employer of the issues and requested accommodations. At the time the claimant quit, she had documentation that she needed intermittent leave due to her medical issues. The claimant was clearly unable to continue working in her position due to a medically verified illness. Reverse AT, no voluntary leaving, bill employer, and void adequate response. In the alternative, I would agree to a rehearing. The claimant submitted FMLA documentation that was discussed during the hearing but not admitted into evidence. Additionally, no testimony was taken from the claimant's witness and no attempt was made to contact him after his call dropped.
The appeal tribunal decision should be modified. The claimant resigned due to medical issues. The claimant did not say she was advised to quit by a medical professional, but she did say she was ordered to take intermittent leave in the event of flare-ups. The claimant also stated that she was never refused time off. As such, the claimant's reason for quitting did not constitute good cause connected with the work for doing so. We should therefore modify the AT decision, voluntary leaving, reimburse an employer not billed, sever adequate response.
Modify the AT, voluntary leaving, reimbursing employer not billed, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2970711, Commissioner Alvarez.
The AT should be reversed. The claimant had been working for the employer, a temporary health firm, when her assignment ended. The claimant testified that she contacted the employer to request another assignment, but she was told that no work was available. The employer's witness was an HR coordinator. She testified as to what she believed the other employer should have said, but she also admitted that she was not aware of the claimant's conversation with the employee. In addition, the employer did not provide a copy of their attendance policy. Because the employer provided only secondhand testimony of the events at the final incident and failed to provide a copy of their attendance policy, the employer failed to establish that the claimant quit. Therefore, the record reflects that the claimant was discharged due to lack of available work. Reverse AT, no misconduct, chargeback, void adequate response.
We should modify the AT decision. The claimant was aware and had acknowledged the employer's policy, which required employees to report their availability within 24 hours of an assignment end date. The claimant is considered to have quit when she failed to report within 24 hours of her assignment ending. Although the claimant alleged that she attempted to contact an account executive, the employer provided sworn testimony that the employer had specific procedures for reporting availability, and the account executive had informed the claimant about the employer's procedures. Since the claimant was aware of the employer's policy, her failure to go through the employer's channel for reporting availability constituted voluntary quit without work-connected good cause. Hence, we should modify the AT decision, voluntary leaving, no chargeback, sever the adequate employer response issue.
Rehear for employer policy.
We have not yet achieved a majority vote.
I would agree to rehear.
Yes, sir, we will rehear this case.
Case number 3048029, Commissioner Alvarez.
The decision is not supportable. The claimant is the only party to provide firsthand testimony. He provided that he called the employer the same day his assignment ended and was told no work was available. As such, the claimant was laid off due to a lack of work. Reverse AT, no misconduct, chargeback, void adequate response.
We should modify the appeal tribunal decision because the record supports the conclusion that the claimant did not report back for reassignment as required by the employer's policy. The claimant is deemed to have quit without good cause connected with the work. We should modify the AT decision, voluntary leaving, no chargeback, sever the adequate response issue.
Reverse the AT, no misconduct, chargeback, void adequate response.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 3052230, Commissioner Alvarez.
The AT decision should be reversed. While the employer had some previous informal discussions with the claimant about teamwork, and the need to get along with others. The claimant was never given any informal disciplinary action and was never made aware that her job was in jeopardy. The testimony concerning the final incident established that the claimant manner of speaking with her coworker was blunt, but she did not raise her voice or say anything vulgar or offensive. Under these circumstances, there was insufficient evidence that the claimant's actions during the final incident rose to the level of misconduct connected with the work. Reverse AT, no misconduct, chargeback, void, adequate response.
We should modify the appeal tribunal decision. The employer presented evidence of the claimant's inappropriate, unprofessional, and bullying behavior, which the claimant did not deny, despite having an opportunity to do so. Furthermore, the claimant acknowledged that the employer had spoken to her about coworker complaints against her. Thus, because the employer met its burden and established that the claimant mismanaged her position of employment, we should modify the AT decision. Misconduct, no chargeback, sever the adequate response issue.
Modify the AT, misconduct, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 305-6406, Commissioner Emerson.
We should reverse the appeal tribunal decision on timeliness. TWC records contain the employer's response to the notice of maximum potential chargeback that was added to our scanned records on September 4th, 2020. Despite the response having been mailed, the document bears no agency receipt stamp and no copy of the envelope was preserved. The employer testified that it mailed the response during the response period. Our UI division provided information about processes for handling chargeback mail and scanning documents. This information states that the time frame from receiving a document in the mail to scanning into our record takes from 3 to 5 business days. We should take administrative notice of this information. Based on this time frame and applying our timeliness rules for mail documents without a postmark, it is clear that the employer submitted a timely response to the notice. The employer should not be penalized because we failed to keep a copy of the envelope. Thus, because the employer submitted a timely response to the notice of maximum potential chargeback, we should reverse the appeal tribunal decision on the timeliness issue and resubmit the case for merits testimony.
The AT decision is not supportable. The employer's response to the notice of maximum potential chargeback was due on 8/31/20. TWC records reflect that the employer's response was entered into the commission's computer record on 9/4/20. However, there was no receipt stamp on the document. At that time, it took at least 6 days for such documents to be entered into commission records. The employer testified that they mailed the response on 8/27/20, which is consistent with the established facts in this case. The preponderance of the evidence establishes that the employer filed a timely response. Reverse the AT, timely employer response to the notice of maximum potential, chargeback and resubmit on merits.
Reverse the AT, timely response to the NMPC, resubmit for merits.
Thank you. We will resubmit the case.
Case number 305-8047, Commissioner Emerson.
We should modify the AT decision. First, I agree that the claimant filed a valid claim. Concerning the job separation, the claimant was aware of the employer's policy which dictated that 5 absences within a rolling 3-month period would result in termination of employment. The employer informed the claimant that his job was in jeopardy after accruing 4.5 absence points. Though the employer had an incentive which allowed employees to receive points back against their tally if they elected to take the COVID-19 vaccination, the claimant was not eligible for the program because he did not take the vaccination by the end of the employer's incentive period. Although the claimant alleged that he had timely taken the vaccination, in his fact-finding statements to the commission, the claimant provided contradictory statement. Since the claimant was warned about his attendance and thereafter exceeded the employer's attendance points for absences, the claimant's conduct constituted mismanagement of his position of employment and was misconduct connected with the work. Hence, we should modify the AT decision, valid initial claim, misconduct, no chargeback, sever the adequate employer response issue.
The AT decision should be modified. The claimant provided firsthand testimony that he got his last COVID-19 vaccine shot before the deadline to be eligible to receive credit for 2 attendance points under the employer's incentive program. By contrast, the employer's contention that the claimant received his vaccine shot after the deadline and that the claimant's vaccine card had been altered was based entirely on hearsay. The AT misconstrued the claimant's prior fact-finding statements to constitute an admission that he received his last shot after the deadline, as the claimant in fact received his last shot before the deadline. He was therefore entitled to receive credit for 2 attendance points in accordance with the employer's incentive program. As the claimant never reached the 5-point cutoff under the employer's attendance policy, the claimant was not discharged for misconduct connected with the work. Modify the AT valid claim, no misconduct, chargeback, void, adequate response.
Modify the AT valid claim, no misconduct, chargeback, void, adequate response.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 307-9497, Commissioner Demerson.
The appeal tribunal decision should be affirmed. I agree that the claimant filed a valid claim. Regarding the job separation, the claimant resigned due to her physical limitations and an increase in workload. However, the claimant was not advised by her doctor to quit. In addition, the AT's conclusion that the employer did not make a substantial change in the claimant's working condition is supportable. We should therefore affirm the AT decision, valid claim, voluntary leaving.
The decision is not supportable. Due to the pandemic, the workload significantly increased. The claimant had a pre-existing injury, which was made worse by the increased workload. The employer provided some temporary assistance, but no permanent solution was implemented. As such, the claimant had good cause connected with the work to quit. Modify the AT valid claim, no voluntary leaving.
Affirm the AT valid claim, voluntary leave.
Short form dissent.
Thank you. Commissioner Alvarez.
Case number 308-1939, Commissioner Demerson.
We should grant a rehearing in this case. The claimant was placed on a final warning for tardiness and attendance issues. The final warning notified the claimant that he would be fired if he was tardy again. In its appeal to the commission, the employer lists several incidents of the claimant's tardiness after the final warning was issued. Since this evidence is relevant to determining whether the claimant was discharged for misconduct connected with the work, we should rehear this case for additional information regarding the claimant's incidents of tardiness after the final warning.
The AT should be affirmed. The claimant was late to work on October 7, 2021. He received a final warning for his absence on October 8th. The claimant was not absent or late again, but the employer discharged him without any reason on October 26th. The employer testified that he was simply tired of the claimant's past performance. Therefore, the claimant was discharged for reasons other than misconduct. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 308-3489, Commissioner Demerson.
The commission should grant a rehearing in this case. The claimant was fired for failing to meet job expectations. Coaching records for the claimant were included in the file documents for this case. The coaching records contain a remark from the employer that the claimant was not implementing behavior from coaching. To determine whether this was a matter of the claimant's choice or ability, we should rehear this case to further develop the record by obtaining testimony from the employer about which behaviors from coaching the claimant was not implementing.
The AT decision should be affirmed. Commission precedent provides that an employee's failure to meet an employer's standards cannot be deemed misconduct unless the evidence clearly shows that the employee demonstrated an ability to consistently meet such standards in the past. In this case, the claimant's mere inability to improve her performance to the employer's satisfaction within her relatively brief tenure did not constitute misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson. And that was the last UI case pulled for additional discussion on docket 14. And you should have received the UI short form dissent list for docket 14.
I move we accept staff recommendations on the remaining UI cases on docket 14.
Chairman, I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 14.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 14.
The motion passes with the exceptions noted.
Thank you. And proceeding to docket 15.
Case number 2648138, Commissioner Alvarez.
The AT decision should be modified. I do not contest that the claimant failure to show good cause for having missed the scheduled hearing. However, the claimant filed her initial claim during a period when the agency automatically backdated claims in response to the pandemic. Because the claimant filed during a period when the agency was automatically granting backdated claims and backdating will not harm the claimant, His request to backdate should be granted. Modify the AT, no good cause, backdated the initial claim to March 15th, 2020.
The AT decision is partially supportable. The claimant did not have good cause for missing the first hearing. On the issue of whether the claimant's initial claim should be backdated, it is clear that the agency's denial of the backdating request was inconsistent with the agency's stated practice at the time. Other initial claims were automatically backdated during the relevant time period, and the same needs to happen with this case. Accordingly, we should modify the AT decision. The claimant did not have good cause to miss the first hearing. Allow backdating of the initial claim.
Modify the AT, claimant did not establish good cause for AT1, backdate the IC to March 15th, 2020.
Thank you. We have a unanimous decision.
Case number 2785146, Commissioner Demerson.
We should modify the appeal tribunal decision. The job separation occurred when the claimant stopped performing services for pay upon advice from her doctor in anticipation of her medically scheduled delivery date. Because the job separation resulted from the claimant's medical condition, the claimant should be qualified for benefits and the employer's account should be protected from charge under medical separation analysis. Thus, we should modify the AT decision, no voluntary leaving, no chargeback, MVI.
I would agree with the MVI.
Affirm the AT, no voluntary leaving, chargeback.
The only issue that is different from yours, your vote, Mr. Chairman, is the chargeback issue.
Yep.
Would you
Short
like
form
to
dissent.
dissent? Thank you, sir.
Case number 2904508, Commissioner Demerson.
The commission should grant a rehearing in this case. In its appeal to the commission, the employer states that the employer's witness attending the hearing was not able to testify to the timeliness issue. The employer goes on to state in its appeal that its records show that the claim responses and appeal requests are timely. Accordingly, we should conduct a rehearing in this case to allow the employer to submit any records reflecting a timely protest and to allow any employer witness to testify on the timeliness issue.
The decision is correct. The employer filed their protest a day late due to issues that in transmitting their information to a third-party claim specialist. The employer did not provide testimony from the claim specialist at the prior hearing, and it's not alleged they were prevented from doing so due to circumstances beyond their control. Affirm the AT, late protest, no misconduct.
Rehear.
We will rehear the case.
Case number 2910421, Commissioner Demerson.
We should reverse the appeal tribunal decision on timeliness. In March of 2020, the employer designated a claims address in order to receive all claim-related documents in the mail. In spite of this, a wage verification form was not sent to the employer's designated address. While acknowledged that TWC can and does maintain multiple employer addresses for different purposes, this can be very confusing to employers. In fact, a review of our website revealed that there is no easy way to determine what address is used for mailing wage verification notices. Here, the employer believed that by designating a claims address, all claim-related documents, such as the wage verification in question, which was generated as a result of an unemployment claim, would be sent to its preferred address. The fact that it was not clearly communicated to the employer that it needed to submit yet another address change to a different TWC department in order to receive wage verifications to its chosen address is the equivalent of misleading or misinformation to the employer about its appeal rights. As a result, we should find the employer's appeal timely and resubmit the case for merits testimony.
The AT decision is correct. The employer filed a late appeal from the wage verification notice. The employer signed up for electronic correspondence and was informed that they needed to regularly check their electronic correspondence inbox. The employer's HR department was not timely informed of the wage verification notice because the employees from another department failed to check the electronic correspondence inbox and forward the information to HR in a timely manner. Since there is no good cause exception to the timeliness rule, we should find that the employer's appeal was late. Affirm the appeal tribunal decision, late employer appeal, and bill reimbursing employer.
Reverse the AT, timely employer appeal, resubmit.
We will resubmit this case.
Case number 2941227, Commissioner Demerson.
The commission should conduct a rehearing in this case. The record was insufficiently developed and the relevant foundational questions were not asked to ascertain whether or when the employer received the charge liability decision from TWC. Since testimony on this issue is crucial to determine whether the employer could have filed a timely appeal, we should rehear this case to develop the record and obtain testimony on when, if at all, the employer received the charge liability decision.
Ms. Miller, I would agree to rehear.
We're here.
We will rehear the case.
Case number 2985045, Chairman Daniel.
Because the employer never received the NMPC, the employer's response should be deemed timely. Reverse the AT. Timely response to the NMPC, resubmit.
The AT should be affirmed. The NMPC was properly mailed to the address provided by the employer on November 20th, 2020. The deadline to respond was December 21st, 2020, but the employer never protested the notice. Affirm the AT, employer response not timely, chargeback.
The chairman, was timely and resubmit?
Yes, sir.
I want to agree with the chairman on that.
Thank you. We will resubmit the case.
Case number 3003242, Commissioner Demerson.
We should reverse the appeal tribunal decision. The claimant had acknowledged the employer's policy, which stated that profane or abusive language was prohibited at the workplace. When the employer questioned the claimant about her use of profanity towards a coworker, the claimant began to act in an unprofessional manner. Since the preponderance of the evidence dictates that the claimant was aware of the employer's policy on proper workplace conduct, but thereafter violated the policy by engaging in inappropriate behavior at the workplace, the claimant's conduct was mismanagement of her position of employment and constituted misconduct connected with work. Hence, we should reverse the AT decision, misconduct, no charge back, adequate employer response.
The claimant was discharged for reasons other than misconduct connected with the work. On the day of her discharge, the employer met with the claimant to discuss her actions on the day before, but did not intend to discharge her. During the meeting, the employer decided to discharge the claimant for not signing a training form. The claimant was not warned that her refusal to sign the form would result in a discharge. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 3004522, Commissioner Alvarez.
This case should be reheard. The claimant's initial claim was avoided because she supposedly did not furnish valid DPS data to verify her identity. Commission records clearly show that the claimant did in fact verify her identity to the satisfaction of ID me before the determinations in this case were issued. The AT did not make an effort to actually obtain the relevant information in this case, even though the claimant testified that she made repeated efforts to contact the commission. The case should be reheard to obtain the required DPS information to verify the claimant's identity so that the claimant's initial claim can be reinstated.
The AT decision is partially supportable and a portion of the claimant's appeal to the commission should be dismissed as moot. I agree that the claimant's appeal from the original invalid claim determination was timely and that the claim was invalid at the time the determination was issued. Thus, the portion of the AT decision dealing with the invalid claim issue may be affirmed. Regarding the late appeal issue with regard to the overpayment determination, which should have included an issue of timeliness of appeal from the voluntary leave and disqualification issue, but did not, that appeal is moot. Since the voiding of the claimant's initial claim effectively voided the work separation and overpayment determinations. Thus, that portion of the claimant's appeal to the commission should be dismissive as moot. Regarding the instructions to the claimant in the AT decision to contact TWC regarding refiling and backdating of her initial claim, the records reflect that the claimant has contacted TWC dozens of times during the 60-day period. It is unclear why none of those contacts resulted in what should have been a simple procedure of taking the claimant's information again to file a backdated claim. Accordingly, we should modify the AT decision. The claimant's appeal from the invalid claim determination was timely. The claimant filed an invalid claim. Dismiss the claimant's appeal from the late appeal ruling from the overpayment determination is moot and send a memo to UIA and OS regarding refiling the initial claim and backdating it to the date of unemployment.
Rehear.
We will rehear the case.
Case number 303-2288, Commissioner Alvarez.
The AT decision should be reversed. The claimant provided sworn uncontradicted testimony that he received the determination after the appeal deadline had passed. His testimony that he could not recall the date which he did receive the determination does not compromise his statement that he received it after the deadline. Commission precedent holds that a party sworn uncontradicted testimony regarding delayed or non-receipt of an agency mailing should be considered persuasive. Therefore, the claimant's appeal should be considered timely, and this case should be resubmitted for merits. Reverse the AT timely appeal and resubmit.
The appeal tribunal decision should be affirmed. The claimant filed his appeal after the appeal deadline and is therefore late. The claimant's testimony regarding the timeliness of his appeal was inconsistent and did not rise to the level of credible and persuasive. There are no good cause exceptions to the timeliness rules. As such, we should affirm the AT decision, untimely claimant appeal, and leave the underlying decision in full force and effect.
Reverse the AT. Timely claimant appeal, resubmit.
We will resubmit the case.
Case number 305-0139, Commissioner Demerson.
We should conduct a rehearing in this case. The claimant was terminated when the employer's investigation substantiated claims of alleged inappropriate conduct by the claimant against the employer's students. The employer provided substantial information in its appeal to the commission concerning the claimant's separation, including the results of the employer's investigation. Since the admission and review of this information is crucial to rendering a decision in this case, we should conduct a rehearing to admit and further develop the record about the circumstances leading to the claimant's separation.
The appeal tribunal decision should be affirmed because the employer gave the claimant the option to resign in lieu of discharge. Under commission precedent, the claimant's resignation did not change the nature of the separation, and the case should be analyzed as a discharge. The employer only provided vague statements that the claimant violated a policy regarding maintaining professional relationship and boundaries between educator and student. The employer failed to state any specific act or omission by the claimant that led to the employer to this conclusion. The employer failed to provide sufficient evidence of misconduct. While the employer has provided additional documents with its appeal to the commission, a rehearing would not be appropriate in this case because the employer had the opportunity at the AT hearing to offer any evidence it deemed necessary and has not provided any good explanation why he did not do so. Affirm the appeal tribunal. No misconduct. Bill the employer's reimbursing account.
Rehear.
We will rehear the case.
Case number 305-7717, Commissioner Alvarez.
The AT should be modified. The claimant was on approved leave from the employer to provide care for her granddaughter. The claimant was the legal guardian of her granddaughter, who was born with a serious medical condition. The claimant was on approved leave from the employer to take care of her granddaughter, and she separated when she filed for unemployment insurance benefits after her paid leave expired. Because the claimant separated to provide care for her minor child was a medically verified illness, she had good cause to quit. And because the separation resulted from the claimant's care of a minor child with a medically verified illness, the employer's account should be protected. Modify the AT, no voluntary leaving, no chargeback due to medically verified illness. Employer is a party of interest.
Agree with Commissioner Alvarez.
Modify the AT. Claimant is qualified, voluntary leave, employer not charged, employer PI.
All right, let me read in the record so that we'll make sure we're on the same page here.
I'm sorry.
I'm going to read into the record to make sure that we're on the same page here.
Yes, sir.
So mine is modify the AT decision, no voluntary leaving, no chargeback, MVI, add employer as a party of interest.
No voluntary leaving, chargeback, employer PI.
Yeah, no chargeback.
And, right, VLOO, CBOO, MVI.
Yeah, yes.
Okay. Yes, sir.
Modify the AT. No voluntary leaving, no chargeback, MVI, employers a party of interest.
Thank you. We have a unanimous decision.
Case number 306-0493, Commissioner Alvarez.
The AT decision should be modified. The claimant injured his shoulder at work and was assigned light duty. He was taking prescribed painkillers for the shoulder injury, and the employer was aware of his injury and his medication. The medication in question made the claimant drowsy, and he inadvertently fell asleep on one day. There is no evidence of the history of sleeping on the job or prior warnings. The claimant's conduct under the circumstances did not constitute misconduct connected with the work, and the employer's account should be protected from charge. Modify the AT, no misconduct, no chargeback due to MVI.
We should modify the appeal tribunal decision. The weight of the credible evidence established that the claimant was sleeping on the job in violation of the employer's policy. If the claimant's medication was causing drowsiness, which interfered with his ability to perform his job duties, the claimant should have notified a supervisor. Instead, by going to get a jacket to make his sleeping arrangement more comfortable, the claimant mismanaged his position of employment. We should modify the AT decision. Misconduct, no chargeback, sever the adequate response issue.
Modify the AT, misconduct, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 306-2069, Commissioner Alvarez.
The decision is not supportable. The claimant was late to work on several occasions due to side effects of medication he was taking for a respiratory illness. The claimant was provided medical documentation confirming that he has the illness. Since the claimant's tardiness was due to a medical issue, he should be qualified for benefits and the employer's account protected from charge. Reverse the AT, no misconduct, no chargeback, MVI.
We should affirm the appeal tribunal decision. The claimant was discharged for exceeding the total allowable attendance points in a 6-month rolling period. The claimant provides multiple reasons for his absences, including taking a medication that made him drowsy. However, the claimant did not speak to the employer about this issue or seek any type of accommodation. Accordingly, we should affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 306-5374, Commissioner Demerson.
Commission should grant a rehearing in this case. In its appeal to the commission, the employer provided additional evidence, including 2 statements regarding the behavior that resulted in the claimant's termination. This evidence should be entered into the record for the commission's consideration, and the authors of the statements should be asked to testify regarding the same. We should therefore grant a rehearing in this case for the employer's evidence to be entered into the record and to request testimony from the authors of the aforementioned statements.
The AT decision should be affirmed. The claimant provided credible firsthand testimony denying the allegations from the employer. The employer had no firsthand evidence to contradict her. Thus, the evidence failed to establish misconduct. The employer has also provided additional documents with its appeal to the commission. A rehearing to consider that evidence would not be appropriate because the employer had not had the opportunity to provide all its evidence at the AT hearing, but did not do so. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 308-4522, Commissioner Alvarez.
The AT decision is not supportable. The claimant provided credible testimony that he was fired when the employer came to pick up their equipment. An email statement from the owner supported the claimant's account when the owner wrote, "Payday is Monday. Just make sure you bring any company property with you to get your final check." This contradicts the employer's claim that the claimant quit by failing to show up for work on the following workday. As to the reason for the claimant's discharge, the employer alleged that the claimant refused to take an after-hours job and was aggressive in an argument with his supervisor. The evidence from both parties established that the claimant did not, in fact, take the after-hours, that both parties established that the claimant did, in fact, take the after-hours job when instructed to do so. As to the argument, the claimant provided firsthand testimony that he simply explained to the supervisor that there had been a miscommunication between the claimant and the customer about the after-hours job. The employer had no firsthand testimony that the claimant argued aggressively or acted inappropriately. The employer failed to provide sufficient credible evidence that the claimant committed misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
We should modify the appeal tribunal decision. The parties agreed that the claimant and his supervisor had a verbal altercation after an hour's service call. The claimant admitted that when he spoke to the owner afterwards, the owner told him that they would talk about the situation later. Despite this, the claimant assumed that he was fired and did not return to work. By failing to return to work and emailing the owner about the claimant's terms for returning company property, the claimant gave the employer the reasonable impression that he had quit. Accordingly, we should modify the AT decision, voluntary leaving, no chargeback, sever the adequate response issue.
Modify the AT, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 311-8380, Commissioner Alvarez.
The decision should be modified. The claimant was not familiar with the UI process. It was unaware he could not receive payments for any periods before his claim. The claimant was in communication with the employer about returning to work and filed immediately after he was informed he would not be rehired. The claim should be backdated to the first week the claimant was unemployed. Reverse the AT, backdate the IC to November 14th of 2021.
The AT decision is supportable. The claimant did not show that the reason he did not file his initial claim earlier was due to misinformation from TWC or for some other reason beyond his power to control. The claimant has not demonstrated a good cause to backdate his claim. Accordingly, we should affirm the AT decision, deny backdating of the initial claim.
Affirm the AT, backdating denied.
Short form dissent.
Yes, sir. Commissioner Alvarez. And that was the last case pulled for additional discussion on docket 15. You should have received the UI short form dissent list for docket 15.
I move we accept staff recommendations on the remaining UI cases on docket 15.
I second the motion except for those cases in which I'm dissenting as reflected on the UI short form dissent list for docket 15.
And I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 15.
Motion passes with the exceptions noted.
Thank you.
Thank you. That's the end of agenda items 3 through 7. We'll take a short break. This is agenda item 8, a discussion paper authorizing the use of the Special Administration Fund.
Good morning, Chairman, Commissioners, Mr. Cerna. For the record, Chris Nelson, Chief Financial Officer. The Special Administration Fund, or Fund 165, was created to receive penalties and interest collected under the Unemployment Compensation Act and has specific allowable uses. Most notably, it funds TWC's labor law programs. The Mixed Earner Unemployment Compensation Program, or MEUC, was one of the unemployment insurance programs authorized by the CARES Act. In June of 2021, TWC withdrew from all CARES Act unemployment insurance programs prior to implementing the MEUC program. However, TWC has identified $52,809.82 in staff and contractor programming costs associated with work performed on the implementation prior to TWC's withdrawal from the CARES Act programs. Since these costs are not chargeable to any Department of Labor federal grant due to not implementing MEUC and there being no other general revenue associated with the unemployment insurance program outside of the Special Administration Fund, staff are seeking commission approval to utilize section 203.202C of the Labor Code, authorizing the use of the Special Administration Fund to cover these costs. That concludes my remarks, and I'd be happy to answer any questions.
Any comments or questions?
None here, Chairman.
None here.
Is there a motion?
I move that we authorize the use of $53,809,082 from the Special Administration Fund to cover administrative costs, including indirect costs incurred working on the implementation of the MEUC program.
Just to concur, that was $52,809.82, Commissioner? I thought I heard a million in there. That's
I
why.
did have million.
Oh.
Somebody's going to be in timeout.
So it's 52,809-ish.
And 82 cents,
82
yes.
cents.
No ish this time.
No-ish. You got the 82 cents on that.
With those corrections made.
Okay.
That's my motion.
So I'll second that motion, but I was not going to second the 52 million, so. Second.
Thank you.
We're unanimous. Thank you. This is agenda item 9 BCY 2022 supplemental childcare distributions.
Good morning, Chairman, Commissioners. Reagan Miller with the Child Care and Early Learning Division. This morning for your consideration is the distribution of $46.25 million in child care stimulus funding to enroll more low-income children in the remaining months of board contract year 22 from May through September. You approved these funds on March 22nd as part of the $314.75 million overall amount of stimulus funding approved for more low-income childcare. This $46.25 million will bring the board's BCY 22 allocation to just over $1 billion. These additional funds are intended to help boards increase the number of children that they're serving in the remaining months of this contract year so that we're better positioned to implement the increased funding we have in BCY 23. As a reminder, the planning estimate that you approved a couple of weeks ago will take us to $1.26 billion next year. In today's discussion paper, we're recommending that the commission consider two criteria for the distribution of funds and that boards meeting both criteria will not be eligible for the supplemental funding. First, boards that have expended less than 20% of their CCF allocated funds. And second, boards whose child care performance is below 90% of their target, both of these as of January, would not be eligible. Based on this criteria, 24 boards would be eligible for funding as outlined in the discussion paper. I want to point out that while 4 boards would not be receiving additional funding based on their current expenditures, they do have enough available funding to continue to ramp up the number of children that they're serving in the remaining months of this contract year so that they are also prepared to serve the higher number of children that we plan to serve next year. And I'm happy to answer any questions.
Any comments or questions?
None here, Chairman.
And none here.
Is there a motion?
I move that we approve the supplemental distribution of the board contract year 2022 child care funding to the boards as recommended by staff and described in the discussion paper.
Second.
It's been moved and seconded. We're unanimous.
Thank you.
Mr. Chairman, Reagan, just real quick. I had an opportunity to attend the African American Leadership Institute event last week, and thank you for having your team and your members there. That's a group that has a very serious interest in childcare issues for both the workers and the employers that are out there. We appreciate the information that you guys got to us, but very, very well received, and they are wanting to applaud your efforts on communicating information out there as well. You guys are doing a real good job with that. So thank you for your support.
Thank you, Commissioner.
Thank you, Mr. Chairman.
This is agenda item 10, the TWC 2021 annual report.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Margaret Hessian, Director of Communications. You have before you for discussion the TWC's 2021 draft annual report to the Governor and Texas Legislature. The report has included the elements required by statute. The current contents include a message from Chairman Daniel, a message from Commissioner Alvarez, a message from Commissioner Demerson, an overview of TWC, a summary page entitled TWC Builds Partnerships, an unemployment compensation trust fund chart, civil rights division data, local workforce development locations. The supplemental report has been referenced in the annual report. It was previously adopted by the commission and will be submitted in conjunction with the annual report as required by statute. Staff is seeking adoption at this time. We are also requesting approval to revise any minor edits, asking Les to hand out some edits we made, minor revisions. Staff is waiting to receive
Thank
any
you.
further edits or directions you might have at this time. Thank you for your consideration.
Comments or questions?
Chairman, I have a comment. First of all, Margaret, I want to tell you what great work that you've done multiple times that you've been to the offices, all offices to discuss this report. So I compliment you and your staff for that.
Thank you, Commissioner.
This year's annual report, and I'm just pleased that each commissioner was given an opportunity to directly communicate to stakeholders regarding the work of each office, the agency, and the workforce boards. It was an opportunity to talk about our vision and work and all the work we do collectively. So again, thank you for the great work you've put forward.
I know the comments. I remember Ed having a discussion with Ed about that exact thought. And so I think it was really good thought process to really have us separate those things out. Good job.
Thank you, Commissioner. Thank you.
I would agree. The format came out nice. It was something new we tried. I think ultimately it does give us a way to really talk about some priorities for the agency. Commissioners, I do want to ask about one thing. Apologies for the last minute nature of this. On page 12, there's a chart about the UI trust fund. The chart is 100% correct. If you're not completely accustomed to looking at UI trust fund charts, this chart would lead you to believe that the trust fund was underwater. Technically, it was on that date. Again, every figure in this chart's correct. We've checked them. I'm wondering if we should take the fourth footnote and either make that bold, change the color, move it up,
Red.
put it in a bar, add a column. The treatment of it, I'm not as concerned about. But what happened in November, just a couple months after the trust fund closed out, and in fact, when we closed out the trust fund for that particular program year, we had some idea that we were progressing toward that payment. I just would not want to lend the impression that at any time or even to the current day that we're not financially solvent, when in fact we are, and it's operating carefully. That is the only suggestion I would have. It just sort of struck me yesterday when I was looking back over this. I would really hate for someone to misunderstand or be misled by what they think they're seeing, because they're not just quite accustomed to sort of reading our charts. If there's no objection to that from the other commissioners, I'd leave it to you to sort of highlight that somehow and talk about what happened. with regard to the money, but other than that, I have no other suggestions for the report.
Chairman, I'm okay with that recommendation since I don't seem to know the difference between 52,000 and 52 million. So my fault, but I agree with you. I'm okay with that change.
Commissioner, I appreciate that. The thing is you dream big and it's always in millions, and I appreciate that. No, thank you very much.
Are you okay here?
Yeah, no objection. So is there a motion on the issue at large?
I move that we approve adoption of the, whoa, what check? We're on 10.
Number 10.
I move that we approve the TWC annual report and submit to the governor's office in the Texas Legislature.
Second,
And I assume, Commissioner, your motion would include the change we just agreed
And
to.
with the additional changes that were made from the dais, Chairman Daniel.
Thank you. I think we're
Thank you
unanimous
very
on
much,
this. Thank you
Commissioners. We're
very
happy to
much.
make that change. Thank you.
This is agenda item 11, chapter 804 JET grant program.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, my name is Abby Austin with the Outreach and Employer Initiatives Division. Commissioners, before you today for your consideration for adoption are final rule amendments to Chapter 804 Jobs and Education for Texans, or the JET grant program. In an open meeting on January 11th, 2022, the Commission approved posting of the proposed amendments to TWC's Chapter 804 rules regarding implementation of recently passed legislation broadening the list of entities eligible to apply for and receive JET grant funds. The proposed rule amendments were published in the January 28th, 2022 issue of the Texas Register for a 30-day public comment period. We did not receive any comments on the proposed rules. Following closure of the comment period, staff did identify the need to make a technical change and amended 804.41 D1 to change the word college to grant recipient. This technical change was necessary to reflect the expanded list of entities eligible to receive JET grant funds. Staff recommends adoption of the Chapter 804 rule amendments as included in today's meeting notebook and published on the agency's website. Should the Commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my presentation. I'm happy to answer any questions.
Any comments or questions?
None here, Chairman.
not here.
Is there a motion?
I move that we approve adoption of Chapter 804 rules, Jobs and Education for Texans, JET grant program.
A second,
It's been moved and seconded. We're unanimous. This is agenda item 12, chapter 800, new subchapter D, employee benefits. It's an ominous start, Mr. Cerny.
I know,
My
wow.
God, I'm scared of that
I don't
guy.
want to come here.
Chairman, Commissioners, I'm Jerry White, Director of Human Resources here at the Workforce Commission. Before you today, for your consideration for adoption are the final rule amendments to Chapter 800, General Administration. In an open meeting on January 11th, 2022, the Commission approved proposed amendments to TWC's Chapter 800 rules to add new subchapter D, implementation of legislation requiring TWC to adopt rules and prescribed procedures relating to the operation of the agency's sick and family leave pools. This is the law change that will set up an additional safety net for our employees who suffer catastrophic or serious or catastrophic illnesses, or adopt children or bring children in the house into their homes as well. The proposed rule amendments were published in January 28th, 2022, issue of the Texas Register for a 30-day public comment period. TWC did not receive any comments on the proposed changes, and no changes were made to the rule language. Staff recommends adoption of the Chapter 800 rule amendments as included in today's meeting notebook and published on the agency's website. Should the Commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with the publication requirements of the Texas Register and the Office of Secretary of State. That completes my presentation, and I can answer any questions if you have any.
Any questions or comments?
None here, Chairman.
None here.
Is there a motion?
I move that we adopt the amendments to 40 Texas Administrative Code, Chapter 800, Chapter D, Employee Benefits as recommended by staff.
A second.
It's been moved and seconded. We're unanimous. This is agenda item 13, chapter 809, child care services.
Good morning, Chairman, Commissioners, Mr. Cerna. Allison Wilson with the Child Care and Early Learning Division for the record. Commissioners, before you today for your consideration are proposed amendments to the Chapter 809 Child Care Services Rules. In an open meeting on December 21st, 2021, the Commission approved a related policy concept and directed staff to draft the proposed rules that are before you today. Staff also posted the policy concept for 3 weeks to solicit input from local workforce development boards and childcare stakeholders. We received multiple comments which staff considered during the development of these proposed rules. The proposed amendments will address several bills passed by the 87th Texas Legislature regular session, including House Bill 2607, which requires all subsidized providers to participate in Texas Rising Star, House Bill 1792, which requires TWC to select a statewide entity for Texas Rising Star assessors, and Senate Bill 1555, which requires TWC to align reimbursement rates with childcare regulations age groups for ratios and group sizes. Additionally, the proposed rule amendments include several changes to improve program service delivery, consistency, and efficiency. Staff recommends submitting these proposed rules for publication in the Texas Register for a 30-day public comment period. Staff also requests the ability to make minor non-substantive changes to the document in order to comply with the publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my remarks, and I'm happy to answer any questions.
All right, hold that thought. We've got some public commenters. Mr. Troman.
Yes, first we have Brooks Jones. Mr. Jones, if you can unmute yourself and proceed.
Hi, my name is Brooks. I'm actually going to be representing TLCCA today. It's a Texas Licensed Child Care Association. We represent several child cares, hundreds of child cares in the state of Texas. I'm excited that we're going to do this in the open 30-day comment period. Some of the notes that we've done when we're reading through it. One, I want to thank Reagan and her team for putting in the work and the rules of these changes. They've done a great job. 80995 providers automated agreement, attendance agreement. We like, as a providers, we would prefer not to see any more POS machines. That was a struggle for us and for our parents. And I know y'all are implementing a CCCMS in 2023. What I'd love to see for that is the third parties to integrate with the attendance portal of that with their current child care management softwares. We use ProCare, Brightwheel, Life Cubby, different providers to choose to integrate so that it can record the attendance that's done on staff on hand already and not add another burden to providers and to families. With the entry level, 809131E, what we're asking for, or what I'm going to be asking for on this one, is to have a shorter time frame other than the 12 months for a new provider. The barrier of entry is getting more steep for providers in low income areas. Now that is a requirement that they become a TRS certified provider. And so what we're asking for is during that time, Reagan's come up with a wonderful scoring and point system, and her team, and I think that's a great piece. But just timeline is what I'm concerned about. We can't apply to be a TRS provider until 12 months after already being open. And if you're to get one of the A citations, then you have to wait an additional 12 months on that initial period. But if you are already a TRS provider, you only have to wait 6 months. And so what I'm asking is that for that first initial one of new providers, to instead of being that 12-month waiting period, to be a 6-month waiting period, so that they can start the TRS process sooner and not get into having to wait that 12 months, causing potential them being off the program with the concern. In 809-135, Texas Rising Star process for reconsideration. Now that Texas Rising Star certification is a requirement as well, I'd like to see more brought in for concerns, complaints, hearings, and appeals for providers. When it was a voluntary program, I can understand why there just needed to be one little policy of that, of a reconsideration done at the board level. But now that is a mandate and directly correlated to our funds, I would like to have more of an appeal process for providers so that our voices are heard. We can go through this process. And actually, I'd prefer it to go back to after the company, the third-party companies picked, potentially with TWC partnership in that appeals process and reconsideration process. And then if we have complaints on the company, a way for us to communicate that as providers, other than our hands being tied. Because I do feel like that's what 809.135 is kind of doing for us. So those are my concerns, and thank you for listening to me.
Thank you. Next, we have Cassandra Camargo.
Can you hear me?
Yes, we can.
Awesome. Good morning. My name is Cassandra Camargo. I'm the Director of Education with Christian Preschool Centers. I appreciate your time this morning and thank you for allowing us this time to have our voices heard. We want to thank you for hearing us in the discussion of the Pre-STAR designation program. By changing that program to the entry-level program with a strong points threshold, I think will be much more beneficial to providers. In reading through the suggested changes in Chapter 809, one item that stood out was 809-132, discussing Texas Rising Star suspension status. One issue that was observed in reading this is the unrealistic goals set with the 12-month suspension timeframe. The way it reads is if a provider gets moved to suspension status, the provider cannot even reapply for reconsideration until after the first 6 months. This is an issue for providers for a couple of different reasons. One, providers aren't able to apply for reconsideration until after the first 6 months, which at this time we are already being penalized by not being able to accept new families. Two, with there being a statewide entity, the provider is to request a reconsideration assessment. That being said, the provider can't request this until after the first 6 months, but before the end of the second 6 months. With us not having the statewide entity currently in place, our assessments were still 2 months out. This being said, I see providers not being able to be assessed in time, causing them to lose their TWC funding for not meeting requirements. Number three, in Section A, there are circumstances such as had 15 or more total high or medium high weighted licensing deficiencies during the most recent 12 months with licensing. If this occurs, the provider would be put on suspension status with no chance to get this corrected within the 6 month to 12 month period and be able to request a reconsideration, which would cause them to provide again, or to cause the provider again to lose their TWC funding. This suspension status still gives no grace to 2-star providers and minimal grace to those that are 3 or 4-star, as those citations may come at a quicker rate with certain ones. My recommendation is to change the time frame to 18 months, allowing the provider time to successfully meet requirements in hopes of continuity of care for the students and families. Again, thank you for your time.
Thank you. And finally, we have Sahara Solis. Ms. Solis, if you can unmute yourself and proceed. Ms. Solis? Hi, Commissioners.
Thank you, Mr. Irwin. All right, any comments or questions for Allison?
None here, Chairman.
And here,
Is there a motion?
I move that we approve the,
Can you hear me?
Yes, we can hear you. Go ahead.
Okay. Is it, may I proceed?
Yes,
Yes.
you may.
Okay, so my name is Sahara Solis. I am the Associate Director of Education at Christian Prison. Thank you for this time to allow me to speak and be heard on the suggested changes on Chapter 809. As these changes have a direct impact on childcare and the services that we are able to provide. Firstly, I wanted to say that I am in favor of Chapter 809, Subchapter 131B2, as it explains the points threshold for high and medium high CCR deficiencies in the most recent 12-month period and the established guidelines. I do suggest that the point system be inserted into this chapter in addition to the guidelines, so that way they would be easier to keep record of and continue to follow. Second, in Chapter 809, Subchapter 20, as the age groups are suggested to change and comply with the CCR age groups, I am suggesting that those changes of the reimbursement rates be given to providers at a 6-month notice, giving the providers 6 months to be able to prepare and budget for these changes to come. Lastly, in the Chapter 809, Subchapter 93, I am in favor for providers being paid prospectively. However, my recommendation is that an amendment be made specifically that if a student is terminated for non-payment circumstances or failure to comply with behavior code of conduct within the school, that the provider does not need to pay back that reimbursement as we work with our families prior to termination in these circumstances. Thank you again for the time to be heard, as I look forward to partnering with you guys, partnering in changes to childcare services and continuing to provide excellent care and education for our students. Thank you.
Thank you, Ms. Solis.
Is there a motion?
Chairman, I move that we approve the proposed rule amendments to 40 Texas Administrative Code, Chapter 809, Child Care Services for publication in the Texas Register and public comment as recommended by staff.
Second.
Two moved and seconded. We're unanimous.
Thank you.
This is agenda item 14, Chapter 817, Child Labor, and Chapter 821, Texas Payday Rules.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Jimerson, and Mr. Cerna. For the record, I'm Jason Stalinsky, Director of the Office of Investigations and Prosecutions for the Division of Fraud Deterrence and Compliance Monitoring. Before you today is a policy concept to amend the Chapter 817 Child Labor Rules and the Chapter 821 Texas Payday Rules. Under Texas Labor Code Chapter 51, Employment of Children, the Texas Legislature granted TWC the authority to issue administrative penalties if TWC determined that a person who employs a child has violated Chapter 51 or Commission rule. Under Texas Labor Code Chapter 61, also referred to as the Texas Payday Law, the Texas Legislature granted TWC the authority to adjudicate wage claims and issue preliminary wage determination orders. Determinations under these chapters become final if not appealed within 21 days of being issued. The rulemaking proposed in this policy concept would allow staff to issue corrected determinations within the 21-day period before a determination becomes final unless an appeal is filed. A common situation where this could occur would be a mathematical error calculating penalties or wages owed. This rulemaking would allow staff to issue a corrected determination rather than requiring a time-consuming and administratively costly appeal. This corrected decision authority already exists within other agency programs. As is current practice, an exception would exist for situations where staff mails the determination to a clearly erroneous address. Staff is also proposing a slight restructuring of the appeal sections within these rules so they clearly follow the corrected determination. Additionally, staff is recommending a technical correction to a definition in the child labor rules to align with the statutory language in Chapter 51. Finally, the four-year rule reviews for Chapter 817 and 821 required by Texas Government Code Section 2001.039 must be completed by January 2023. As part of this policy concept, staff proposes reviewing the rules to ensure they align with the current program processes and procedures and address any proposed changes in the proposed rules. Today, staff seeks approval to move forward with developing the proposed rules and reviewing these chapters as outlined in the policy concept. I'm available for any questions you may have.
Comments or questions?
None here.
Not here. Thank you.
Is there a motion?
Chairman, I move that we approve the policy concept for amending Chapter 817 and 821 as discussed by staff.
A second.
It's been moved and seconded. We're unanimous. This is agenda item 15, approval of recertification of community rehabilitation.
Good morning, Commissioners. Mr. Sedna, for the record, Lizette Hinojosa with Vocational Rehab. Today before you have a discussion paper regarding the approval of recertification of community rehabilitation programs to participate in the Purchasing from People with Disabilities State Use Program. The Texas Human Resource Code requires the Texas Workforce Commission to establish rules for the certification of community rehabilitation programs, or CRPs, to participate in the Purchasing from People with Disabilities Program. TWC Chapter 806, purchases of products and services from people with disabilities, Rule 806.41 establishes requirements for participation in the program and subsequent adherences to those requirements when a CRP has been certified. CRPs must reapply every 3 years before the expiration date on their certificate. The PPD program has reviewed the applications of 4 CRPs seeking to continue participation in the program through recertification. All 4 CRPs pay minimum wage or higher. And those are starting with number 1, a Lift for Life Outreach Center out of Dallas. Number 2 is Janie Clements Industries Center for Life Resources in Brownwood. 3 is Goodwill Industries of East Texas, Tyler. And lastly, Marion Moss Enterprises out of Lubbock. Staff recommends the recertification of the 4 CRPs for continued participation in the PPD program, and I am available to answer any questions.
Any comments or questions?
None here, Chairman.
None here.
Is there a motion?
Chairman, I move that we approve recertification of the community rehabilitation programs to participate in the Purchasing with People with Disabilities Program as recommended by staff.
Second.
It's been moved and seconded. We're unanimous. Thank you. This is agenda item 20, board nominations.
Good morning, Chairman, Commissioners, and Mr. Sarna. For the record, Cherie Dudley with the Workforce Development Division. For your consideration this morning, we have workforce nominations for Capital Area, Concho Valley, Lower Rio Grande Valley, and Southeast Texas. Staff seeks guidance on the presented nominees, and I'm here to answer any questions you may have.
Comments or questions?
None here.
None. Thank you.
Is there a motion?
Chairman, I move that we approve the board nominees for Capital Area, Concho Valley, Lower Rio Grande Valley, and Southeast Texas.
Before I second the motion, I did want to point out Workforce Solutions Capital Area. They're appointing the private sector appointee Walter Gonzalez from Tesla, a new company in our state, and glad to see that appointment being made on that board. So
Yeah.
I second the motion.
It's been moved and seconded, and we're unanimous.
All right, thank you.
Thank you. A legislative report by Michael Britt. Right. The Michael Britt. All right. I'll try to remember that. The Michael Britt.
Good morning, Mr. Chairman, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, the Michael Britt, Governmental Relations. Last week, the U.S. House and Education and Labor Committee held a markup of HR 7309, which is the Workforce Innovation and Opportunity Act of 2022, and passed the amended bill to the full U.S. House of Representatives. At this time, that U.S. House leaders have not announced a timeline for that bill to be taken up by the full House. We will, of course, keep you updated as that timeline is announced. With the state legislature, both the Texas House and Texas Senate have issued their interim charges for the 87th Texas legislature. And a summary of those interim charges relevant to TWC have been provided to your offices. But on that note, TWC has been requested to testify before the House Committee on Business and Industry on April 27th. The committee will be taking up 2 interim charges at that hearing related to TWC. One is related to operational changes and strategies employed by TWC to improve outcomes related to UI benefits. And the other charge is related to studying the impacts of the pandemic on unemployment trends, hurdles to the workforce, reentry, and industry-specific disruptions. Mr. Cerna will be testifying at the hearing on both of these interim charges for the agency. This concludes my remarks. I'm happy to answer any questions you may have.
Any comments or questions?
None here, Chairman.
None here.
Reserving my right to strike the from the Michael Brooks. Thank you. Mr.
Thank you.
Is there an executive director's report today? Thank you very much. Is there any other order of business to come before the commission?
I have none.
Thank you.
And I have a number of things I want to bring up real quick. Not
Besides the picture that you were in. That was a good picture.
Not any serious issues here. But first, I wanted to thank the public commenters, those are childcare providers and those employers that are out there. They continue to provide input and we continue to appreciate their input. Commissioner Alvarez, we had a chance to read the healthcare apprenticeship report where we're replicating and scaling the nursing programs. And so employers are pretty excited about that report. And so appreciate, didn't have a chance to recognize that last week, but wanted to let you know that the employers are pretty excited about the additional opportunity that they'll have to that program as we address the nursing shortage here in the state. Last week, I had an opportunity to go out to Bloom Consulting. This is Autism Month. And this is a company, we had a hireability ceremony, and over 30% of their employee base are folks with disabilities. And so that's kudos to that company and the work that they're doing in that space as we continue to go out. Ed, Melinda and the team have been phenomenal in the sense of getting out there doing work in that regard. So thank you for having that. We also had a TCE, Texas Conference for Employers, where over 500 employers were signed up. And so kudos to Julie and her team, and then Margaret and her team for the work that they're doing to put that on. We did a virtual conference right here in this room, well attended and well received from that standpoint. But I wanted to point out to Ed, thank you guys for allowing the team to work in that regard. And then lastly, saw Jerry here, but the Capital 10,000, a 10K we did, the TWC had a team, a number of individuals who were part of the team, and they were out running, representing the agency in a big way. Cassandra Medrano on my team was an ambassador for that race. And so there was the wellness program was well represented with TWC. And thank you, Ed, again, for the support of those efforts. And so, Chairman, thank you for the opportunity.
Thank you. Any other order of business?
I don't know, Randy, is there anything you'd like to announce? Maybe someone who may be retiring soon that just walked in? Ed, would you like to make an announcement for the record? No? Oh, okay, well.
Is there a motion to adjourn?
Chairman, I move that we adjourn.
Yes, I'll second that motion.
It's been moved and seconded to adjourn, and we're adjourned.